There are hundreds of thousands of employees that are facing job loss, federal agency employees. And we're all sitting here going, yeah, we know. Yes, that's the point. And it even restricts Trump from planning personnel actions, okay? It's not only you can't fire them, it's you can't even plan to fire them. The Trump administration doesn't need them. If the union wants to go hire them or, they can go work for a state government or somewhere else, that's fine. But they're not entitled to this. Trump goes to the Supreme Court of the United States, and he's now demanding that he can, do his job because they have been pretty quiet on a lot of key issues that we would like them to resolve so Trump can become and effectuate the role of the presidency. But we're now in the Supreme Court, and this is a lawsuit that was brought by the AFL-CIO, the unions suing the federal government. Trump came in, said all these contracts are canceled, you're not getting any more money, and the union sued, basically saying that if you're a federal employee and you have a union, the union, once you get fired as a federal employee, the union will suffer, right? If their union bureaucrats are fired from the federal government, then they can't skim off the top of their dues. So they sued, and they're like, hey, wait a minute. We need those bureaucrats to continue working because we need to collect money from them, and they're getting paid from you. So what do you think's going on here? So AFL-CIO sued, and we were battling this puppy out until we got to the Ninth Circuit Court of Appeals. They say there's been a bunch of declarations, and there's a startling transformation that's happening because of Trump and what they're doing. There are hundreds of thousands of employees that are facing job loss, federal agency employees. And we're all sitting here going, yeah, we know. Yes, that's the point. Now, because that's upsetting to you doesn't mean you have the right to change that political decision and change that judgment. If you want to do that, you should run for president. But what they do is they say that is economic loss. Okay, that is injury. That is irreparable harm. That the government can't make any changes because somebody who's downstream of this entire thing might be harmed at some point in time. It's this Ninth Circuit saying this, which is wild because just apply this to COVID, okay? Now, aside from the obvious economic harm of loss in salary, others are going to be forced to relocate and go get new homes. Now, their declarations also show a very substantial downstream impact of these large-scale reductions, reaching far beyond the walls of the executive agencies. Pulling a small handful of examples from the record, we point out that the current executive reorganization facilitates the proliferation. All these are the parade of horribles. We got it. If Trump fires these people, you know what's going to happen? We're all going to die. Proliferation of foodborne diseases is going to ravage all of us. It's going to contribute to hazardous environmental conditions. Yeah. Hinder efforts to monitor and prevent infectious disease. Oh yeah, they're good at that. They did a great job on that last time. And eviscerates disaster loan services for local businesses. Yeah. Which the federal government has been the disaster when it comes to local businesses and to other disasters, and drastically reduces the provision of healthcare and other services to our nation's veterans. Now, defendants' only response is they're saying Trump, this is the Court of Appeals, his only response is that they can just get back pay, okay? If they're right and we're wrong, they can sue for wrongful termination like anybody else in the whole world can, right? You get fired from your job, isn't it? You just sue, and the judge says, no, you can't fire him forever. Why? Because someone else who's close to you is going to be upset that you lost your job. They can sue for you to get your job back so that they can skim off your salary. What kind of bizarro land is this? And why are federal employees unionized? The record indicates that what the defendants have sought to do is anything in the ordinary course, and back pay is inadequate because they're going to have to move. And back pay does not reinstate entire agencies' offices and functions. Yes, you have to leave your bureaucratic hellhole. Go find someplace else. It cannot account for harms resultant from loss of income in the interim or for gaps, and it does nothing to address the breadth and the severity of harm alleged by the dozens of non-federal employee plaintiffs in this case, okay? So non-federal employees, it's not even the people who are being fired. It's the people who are downstream of the people who got fired. So that's what the Ninth Circuit came out and said. And Trump said, all right, enough of this, ridiculous. Supreme Court, will you please do something about this? D. John Sauer, Solicitor General for the Trump administration, says this to the Supreme Court of the United States. They say, listen, basically, Supreme Court, the entire federal government is bound into this lawsuit because of these lower level judges who are maniacs. Look at everybody on this list. Chris Wright, Energy, Lutnick, Kristi Noem, everybody, Pam Bondi, everybody that you've ever heard of is on this list. Okay, they're suing everybody. Now, the respondents are the unions, the AFL-CIO and the rest of them, sending sending in this lawsuit in conjunction with other states and counties and a bunch of other people. A bunch of other cases are percolating along the same line. And so here is what D. John Sauer writes to the Supreme Court of the United States, explaining. All right, Supreme Court, the lower level district court entered a nationwide injunction that covers nearly the entire executive branch, 19 agencies, including 11 cabinet departments, from implementing an executive order that directs agencies to prepare for lawful reductions in size. Okay, it's like the whole executive branch. Now, that injunction, which stops Trump from doing what he needs to do to fire these people or to even prepare to downsize, it rests on the indefensible premise that the president needs explicit statutory authorization from Congress to do his job. So he's got core Article 2 powers, but they say that he needs permission from Congress to use those, and that they can superintend the internal personnel decisions of the executive branch, which is a strange thing to think about because we have the separation of powers, which everybody learned about in social studies and civics class. But under our Constitution, the executive power, all of it, is vested in a president who must take care, also in the Constitution, that the laws be faithfully executed. Quoting the Constitution, Article 2, Section 1, Clause 1. Take care that they're faithfully executed. And cares capitalized, as we always point out. What does that mean exactly? Controlling the personnel of the federal agencies lies at the heartland of this authority. The Constitution does not erect a presumption against presidential control of his branch, and the president doesn't need special permission from Congress to actually exercise his core Article 2 powers. The district court's injunction violates these bedrock principles, as well as other established doctrines. Now, as Judge Callahan explained below, who dissented, applicants have shown a likelihood of success and irreparable harm because some maniac judge issued a sweeping preliminary injunction that strips the executive branch of control over its own personnel, judges in charge, and the unions. Now, the unions improperly bypassed the comprehensive administrative scheme that Congress has enacted to handle federal sector labor and employment disputes. There's a whole separate provision and other agencies that deal with this stuff. You got fired, you're unhappy about it, you're a federal bureaucrat, go use these provisions. And the district court erroneously concluded that the executive's actions likely violate separation of powers without making any finding that the agency's reduction in force is likely to violate any statute. And despite the president having constitutional power. Now, the Supreme Court, they say, you recently intervened in another maniac case to stop some other district judge from undoing the effects of the lawful large-scale termination of probationary government employees. Office of Personnel Management in another case that was back in April. So you, Supreme Court, should do the same thing here, where this injunction is far more broad. It covers most of the federal government, and it even restricts Trump from planning personnel actions, okay? It's not only you can't fire them, it's you can't even plan to fire them. So just sit there and have these people work indefinitely. Now, as this court has recognized, Supreme Court, federal courts do not possess a roving commission. They can't exercise general legal oversight over the executive branch. And furthermore, it is within the president's authority to manage and run the executive branch. Now, in February, pursuant to his authority, President Trump came out. He issued an executive order directing the federal agencies to promptly undertake actions to initiate large-scale rifts. We were here for that, and it was delicious. The president's order rested on firm legal footing, followed a long historical tradition. In fact, for about 150 years, Congress has recognized the executive branch's authority to carry out reductions in force as the need arises. There are other statutory preferences for veteran status and other factors, and it's all in the law. There was a Supreme Court case about it called Hilton versus Sullivan. Look it up, 1948. The executive has repeatedly exercised RIF authority before. In fact, in 1993, Bill Clinton ordered all federal agencies with more than 100 employees to eliminate not less than 4% of their civilian personnel positions. Within 3 years, they did it, aiming for a government-wide reduction of about 100,000 federal workers. And no injunctions were issued then. Now, nearly 3 months after Trump issued his order, however, several labor unions, advocacy groups, and local governments, like the respondents, they all sued the president. Almost every executive department and other federal defendants, and they took this where else to the forum that they love, California. They sought to enjoin implementation of Trump's order and a follow-on memo jointly issued to everybody else, right? So they sent this planning memo from the OMB, get ready, start packing your bags. Everybody, your job tonight, your homework, bring in a cardboard box with you tomorrow. The district court quickly granted a universal injunction. Oh no. First, as a putative temporary restraining order, then as a preliminary injunction, stopped Trump from firing anybody, went up to the Ninth Circuit as we saw. Now this court should now stay their injunction. Let just fire these people. There are multiple flaws here. To start, Supreme Court, they can't directly challenge the RIFs for at least 4 reasons. These are good ones. 1, RIFs are indisputably permitted by federal law. It's in the law. Take a look at Title 5, U.S. Code 3502. Read it. 2, the executive order directs preparation of RIFs only as consistent with the applicable to the law. Okay, so the executive order is telling everybody to follow your own laws as they apply to your agencies. There was also an admonition that it said repeatedly, follow the law. So no one's doing anything that's outside of the ordinary course of a reduction in force. 3, many of the RIFs have not even been finalized, so they're suing over something that hasn't happened. We can't even plan. And 4, any challenges to the RIFs themselves have to go through a special administrative and judicial review scheme that is codified under other provisions of the law. We have the Civil Service Reform Act, if you're a civil servant, so-called, who's upset about being fired. So here, facing these obstacles to any direct challenge to the RIFs, respondents have instead manufactured an objection. They just make it up. They say they cannot end run all those obstacles, we say, merely by suing and bringing this up here, which is what they've done. Now, the general direction and guidance contained in our memo are unquestionably lawful. The entire executive branch belongs to the president and the president alone. Doesn't have to go consult with Hakeem Jeffries before he fires a bunch of bureaucrats who work in the executive branch. That includes the power to effectuate policy objectives by directing agencies to use their already statutory confirmed authority to conduct the RIFs. The district court turned the constitutional structure upside down, shifted the burden by treating as supposed evidence of unlawful action the mere prospect that agencies are acting at the direction of the president and his team. Just the prospect. Wild. Now, equally meritless is the district court's objection that the president may not, without Congress, fundamentally reorganize the federal agencies. And that's what I guess they're saying Trump is doing without Congress. Now, what are you talking about, Judge? You're just making stuff up. It says the executive order makes clear that in proposing RIFs, agencies should ensure they do not eliminate any subcomponents that are statutorily required in there or prevent the performance of functions that are mandated by statute or law. And the memo, and by the way, like Trump hasn't done anything because the judge stopped them from planning or firing or doing any of these things. So they're complaining about something that hasn't happened yet. The order says this is not going to happen, and they're upset about something that hasn't happened yet. Now, the memo reaffirms, look at the law and follow the law and the authorities that you've already got. The president does not need additional authorization to direct any of this. To conduct RIFs, all of this are within the bounds. Congress already explained what the rules are, and they're following it. Now here, the AFL-CIO and neither the court below, they all failed to show that a single agency's organic statute would be violated by any proposed RIF at all, much less that any such violation would actually be traceable back to the executive order, Trump, or the memo, rather than to the agency's hypothetical failure to follow the order's clear instructions to pursue the RIFs in compliance with the law. Now, exacerbating matters, the district court then joined a parade of other courts. They all entered universal improper injunctions extending relief far beyond what was necessary. It also enjoined almost 24 executive agencies. Like, it's a judicial takeover. It's a coup where they can just say, you're done. 24 executive agencies. Plus, anyone acting under the president's authority from implementing any RIF pursuant to the executive orders, regardless of whether the determination at issue would have any effect on the respondents in the case. Okay, so even people who are not a party to the lawsuit are now being protected, just like the illegals, because they get class action protection too. Now, turning to the equities, the district court's flawed injunction, and the equities is this idea we're balancing the harms to each side, measuring the benefits to each side, and weighing them out against each other. Inflicts ongoing and severe harm. They say, we need you to intervene here, Supreme Court. What this lower level judge and the Ninth Circuit are doing are interfering with our internal operations and our unquestioned legal authority to plan and carry out these firings. And it does so on a government-wide scale. Basically, everybody is caught up in this. Now, more concretely, the injunction has brought to a halt numerous in-progress RIFs in more than a dozen agencies, sowing confusion about what RIF-related steps agencies may take and compelling the government to retain at taxpayer expense, right? All these people just sitting there, probably not doing anything useful because they were fired and then unfired, or probably know they're about to get fired, right? The probationary employees and all the people who are at the low end of the totem pole here are now in this limbo status. And the court says you can't make any changes. Everybody has to just keep collecting their paycheck. And of course, we're paying for that. Now, thousands of employees whose continuance in the federal service that they deem do not need to even be in there and are definitely not in the public interest. And so D. John Sauer submitting this saying you need Supreme Court to stay the district court's injunction and allow us to do our job. The statutes and the the law, allow us to do it. As World War II concluded, it was widely understood the federal government would need to shrink dramatically as the nation shifted to peacetime footing. We had a bunch of laws passed, and Trump is building upon those. The executive order was just like Clinton's order, and it had a bunch of various exclusions for public safety and immigration enforcement and many other things. And we issued a memo, and it made direction to other agencies to follow the law, which of course they would do if we were allowed to move forward with this. We held a hearing back on May 9th, and the judge issued a TRO, an injunction, a restraining order the same day. Then we took this up to the Court of Appeals. Under the district court's order, everybody is limited, right? Everybody. OMB, OPM, US DOJ service, 19 agency defendants, all these people now limited on how they can manage their own agencies. On May 30th, the Ninth Circuit came back out. It was a 2-1 decision over there, and the judge dissented below. Judge Callahan explained that we are effectively challenging the prospective termination of the federal employees in the aggregate, but they are all precluded by the law, right? There's other statutory schemes that they could follow. If they're unhappy that they're a bureaucrat that got fired, there's many other avenues upon which they can go for back pay, for damages, whatever, but they can't stop the entire federal government from doing their jobs. Now, respondents' claims were not justiciable in the district court. They say, first of all, the court lacked jurisdiction. District courts have jurisdiction over civil actions that arise under the Constitution, but there are other statutes that have set up other avenues, like the Merit Systems Protection Board and others. When you're in employment with the federal government, your claim, if it's a breach of employment claim, it goes over here. You don't file in the district courts, which is why we've created these frameworks. This framework precluded the lower level district court from even exercising jurisdiction. They need to go sue in the right forum. That's why we made it up. At bottom, this case is a dispute about employment relations in the federal sector, and they go over there. Even the district court admitted that. Numerous courts in recent months and years have applied the same preclusion principle to similar suits, citing a bunch of cases there. The district court's aberrant jurisdictional analysis was unsound. The judge said, well, I'm going to keep jurisdiction anyways, like we've seen in many other cases, because they find some constitutional component to their claim. They're like, well, it's not about employment, it's about the due process in the firing and losing of the employment. I think we saw one where it was not about the contract that was canceled, it was about the decision to cancel the contract. That's what the suing was. What? That's resulted in the firing. No. We're stopping the decision. She doesn't have the power to make that decision. So finally, they write to the Supreme Court. The courts below noted that even if the union respondents and their members could seek relief, the other respondents, the nonprofits, the local governments could not. And so this case should not be here. Now, regardless of whether the lower court had jurisdiction, they lack alternative claims as well under the APA, or ultra virus causes of actions, and their claims are meritless. The legal basis for the memo and the order that came out from Trump are lawful, all codified very clearly under the law. Consider the executive order. Now, in addition to the president's own statutory authority to oversee the civil service, he's got this little thing called, Article 2 of the Constitution, and all of the executive power, all of it, according to SELA law, is vested in a president. Now, the court has applied this principle before, specifically in the RIF context. In fact, in Nixon versus Fitzgerald, 1982, the court explained it clearly is within the president's authority to prescribe the manner in which people in the branch do the business. And our structure presumes that they will be subject to the president's superintendence. Our memo is the same. It's very similarly sound and follows all of these other regulations. You see these CFRs, Code of Federal Regulations here. Now, as for the Office of Management and Budget, there's also statutory provisions that allow them to do what they're doing. And a RIF is not a reorganization. Okay, so don't try to reframe it as that. That generally refers to a restructuring. No one is saying to do that, but neither the respondents, unsurprisingly, or the lower courts showed that any of the ongoing or impending RIFs actually exceed statutory strictures, right? Where is the actual harm going to come from? Like, what law is being violated? You say he's violating Congress? How? Tell us how. They only offered a conclusory, speculative, and unripe allegation to that effect. They said like this: there is no possible way that the AmeriCorps employees can perform the work needed to run this agency in compliance with its statutory duties. That's their language, okay? There is no possible way. Wow, okay. So how many people are going to be fired? We need more than just that. It's just a conclusory spec. And is that true? Like, there is no possible way? So Trump can't fire anybody as long as somebody comes in and like, that's the evidence. My business is going to be destroyed. Why? Well, there's no way I can do it. Okay, well, I guess that's right. I guess you're a government worker for the rest of our lives. So likewise, the district court said only that it was not convinced and had significant questions about this. And that's it. Now, saying that alone is enough evidence to call this whole thing unlawful is ridiculous. The courts below fair dared know better when they were analyzing large-scale rifts. They said even Bill Clinton nuked 100,000 people. They didn't scream about it then. The lower courts additionally faulted OMB and OPM by saying that they were using too much power. With very little analysis, the district court also concluded that they engaged in rulemaking and said they broke the law in other ways. So the injunction is overbroad. D. John Sauer tells us that the Supreme Court is likely going to grant this because it is going to harm the executive branch, not them. More concretely, the consequences here are stark. The injunction has disrupted and brought to a halt a complex government-wide effort, which began with President Trump's executive order more than 3 months ago to prepare for and to execute these RIFs. It stops more than 20 executive branch entities and any other individuals acting under their authority or the authority of the president from doing anything. All of this is delaying and disrupting our work. Now, the inevitable consequence is to compel federal agencies to keep large numbers of employees on the payroll without necessity. The Trump administration doesn't need them. If the union wants to go hire them, or they can go work for a state government or somewhere else, that's fine. But they're not entitled to this at unrecoverable taxpayer expense, thereby frustrating the government's efforts to impose budgetary discipline and build a more efficient workplace. You can't have that. You have to pay them. These are their foot soldiers. They have to get this money coming in. Otherwise, the unions can't donate back to the Democrats. Saying here, this is costing a lot of money. The Congress appropriated the money doesn't mean that it should be wasted, does not mitigate the obvious injury from unnecessarily wasting appropriated funds, right? Which is great. They say, well, Congress said that you have to spend that money. That's fine. Don't have to spend it on these losers. They're all gone. We're firing all of them and we'll spend it. Don't worry about us. This is the government we're talking about. We'll spend that money. We're in the cutting phase right now. We will be bulking. Don't worry about that. But not with the same employees as the last guy. So they're gone. Just because it's appropriated doesn't mean we have to spend it on Democrats. Now, this court has expressed concern about the intrusion inflicted by this court order. Say this was a problem when they tried to reinstate a single government employee. You remember that. Now we have to reinstate every government employee. It follows that a universal injunction freezing a much broader layoff unquestionably inflicts substantial and irreparable injury on the government as the employer. And this injunction has sown confusion over the executive branch. Can we fire anybody? What's a RIF? The caveat that agencies may engage in their own internal planning does not mitigate this problem. They say we can't even discuss these things. And it's inviting a lot of needs for clarification from the court. Now, their assertions of irreparable injury, they say, well, if the bureaucrats are fired, then we can't collect our dues. That is not enough to stop us from executing the law of the executive branch. The district court primarily rested its finding, and union members would be hurt. Now, that form of injury is by no means irreparable, right? They can just get more money because employees can seek reinstatement and back pay through the proper channels. Now, that this case implicates more than one individual employee doesn't mean that everybody gets the same remedy either. Maybe they're fired for different reasons or whatever. Now, the district court also cross-referenced its finding with respect to other respondents and their standing, saying, wow, yeah, federal agencies may be delayed, local government tax bases may be reduced. And so if you're downstream, saying these are speculative, indirect downstream harms, and that was sufficient for standing. They say, no, it's not. Irreparable injury is also not there either. And so those standards were not met. Now, if the employees who face RIFs are not themselves entitled to relief as an equitable matter, it would turn equity on its head to grant them injunctive relief because there's a bunch of them. And for the foregoing reasons, you guys need to do something about this. So Supreme Court, we're knocking on your door. You should stay this May 22nd order that was also affirmed by the Ninth Circuit. And we request an immediate administrative stay of this case to the Supreme Court of the United States.